method to prove the contradiction is provided under Section 145 of the Evidence Act, read with Section 162 of the Code of Criminal Procedure. Now let us understand how a contradiction can be proved during the trial. So once the examination in chief is completed by the public prosecutor and the witness deposes something contradictory to the previous statement, then during cross-examination by the defense, first his attention has to be drawn to that part of the statement made before the police which contradicts his statement in the witness box. The next step is that the attention of the witness drawn to that part must reflect in the cross-examination. Third, while recording the deposition of the witness, it becomes the duty of the trial court to ensure that the part of the police statement or case diary with which it is intended to contradict the witness is brought to the notice of the witness in his cross-examination. Fourth, ideally the relevant portions of the case diary statement used for contradicting a witness must be extracted fully in the deposition. If the same is cumbersome, at least the opening and closing words of the contradiction in the case diary statement must be referred to in the deposition and marked separately as a prosecution defense exhibit. The next stage is that if he admits to have made the previous statement, then no further proof is necessary to prove the contradiction. The contradiction is brought on record and it is also proved. It can be read while appreciating the evidence. But if the witness, after going through the earlier statement, denies having made that part of the statement, then it must be mentioned in the deposition. By this process, the contradiction is merely brought on record, but it is yet to be proved. Thereafter, when the investigating officer or the officer who recorded the said statement is examined in the court, his attention should be drawn to the passage marked for contradiction. After going through the police statement, if he says that the witness had made that statement, then the contradiction can be said to have been proved. If the witness was not confronted with that part of the statement with which the defense wanted to contradict him, then the court cannot suo motu use of statements to police not proved in accordance with Section 145 of the Evidence Act. So this process has to be followed. His attention has to be drawn to that part of the statement. It has to be recorded in the deposition. He has to be shown those parts of the statement, and his explanation is required. And if he denies making that statement, then the contradiction is merely brought on record, but thereafter the officer who had recorded his statement or the investigating officer has to be shown those parts of contradiction, and thereafter if he says that those statements were made by the witness, then the contradiction is brought and proved on record. In several cases, it is seen that the witnesses do not support the case of the prosecution and resile from their earlier statements made before the police. So in such circumstances, when the witness resiles from his earlier statement or does not support the case of the prosecution, he is declared as a hostile witness by the trial court, and thereafter, with the permission of the trial court, the public prosecutor then has the right to cross-examine him. Now, in such cross-examination, the earlier statement which supports the case of the prosecution will have to be brought on record and thereafter will have to be proved in accordance with the provisions of the Evidence Act. If the earlier statement are not brought on record, then the court will not be in a position to make use of the earlier statement made by the witness, wherein he might have stated what is correct and true to the police. Now, in such situation, the public prosecutor will have to cross-examine the witness, and the public prosecutor will have to draw the attention of the witness to his earlier statement, which will have to be recorded in the deposition. Next step is that the earlier statements will have to be marked in the deposition, and thereafter he will have to be asked whether he had made such statements to the police or not. If he denies, then the marked portion of his statements will have to be shown to the investigating officer or the officer who had recorded his statement, and he will have to be asked whether the witness had made such statement before him. And if he says yes, the witness had made those statements when he recorded his statement, in that circumstance, the earlier statement can be used by the trial court for evidence. Otherwise, if this procedure is not followed, then the earlier statement made to the police, even if it is correct, will be of no use, and the court will not be in a position to look into such statement.